So part one, marketing claims of convention promoters. To begin with this, I want to play with you a little bit with a brain teaser. Billy's mother has 3 children. And the 3 children, first one's name is Penny. The second one's name is Nicole. And the third one is what? Quarter? No. George? No. I have all kinds of different suggestions that come up here. This should be obvious, but it generally isn't. Listen to me again carefully. Billy's mother has 3 children. The first one's name is Penny. Second one is Nicole, and the third one is, now I'll do it slowly. Billy's mother. Whose mother? Billy's mother has 3 children. So who's Billy? One of the 3 children. So if there's one named Penny, the next one's Nicole, the third one is Billy, right? That should be immediately obvious except for one thing. What is the purpose of these coins? They serve as a distraction. They're intentionally there to deceive you, to help you not see the obvious answer. This is a common marketing tactic to get you to focus on what we want you to focus on rather than something that might not persuade you to believe the way we want you to. So this is a tactic that we're seeing being used with our state legislators. I'll demonstrate. We'll use the penny to represent the first one. They'll tell our state legislators this Article 5 convention was put in the Constitution for such a time as this, for the very purpose of reining in an out-of-control government that refuses to obey the Constitution. That's the false claim, as we'll demonstrate momentarily. The second claim, they'll tell you that this is the only solution big enough to solve the problem. Again, false claim. But if you believe both of these, this is a foundation for which they'll put blinders on you now. Once you believe these two things, when someone like myself comes along and says they're misleading you with some of their claims, you're going to cling to, this is what Article 5 Convention is for, and it's the only hope. And if I come along and I'm taking away from you what you believe is the only hope for our nation, you have a tendency to resist and fight against it. And hopefully we can take off those blinders for a moment and give an honest assessment of what is Article 5 really for? What are solutions that the Founding Fathers really recommended for such a time as this, when the federal government is clearly overstepping their bounds? There's a third claim that they often make, and this is based on history. There's ever a debate on whether or not historical precedent is a concern here. They'll tell you this Article 5 convention will be totally controlled by the states, and don't worry about any historical precedent, such as the 1787 convention where our current Constitution was written. They'll tell you that was not a runaway convention. That convention stayed well within their bounds of what they were instructed to do. So we have no concerns. No such conventions have ever exceeded their authority. You get an idea of what some of the concerns that are being raised might be there. So let's examine these. First of all, solutions according to the Founding Fathers. When they talked about using the Article 5 convention for proposing amendments to the Constitution, here are some of their quotes. Article 5 is for, Alexander Hamilton tells us, for supplying for any defects that may be found in the Constitution. Here's the way to correct those. James Madison tells us Article 5 is for the amendment of errors in the Constitution. Madison also says, should the provisions of the Constitution, as here reviewed, be found not to secure the liberty and happiness and safety of the people, then amendments to the Constitution through Article 5 are appropriate. Washington's farewell address, if in the opinion of the people, the distribution or modification of the constitutional powers be in any particular wrong, let them be corrected in the amendment process as the Constitution designates. They're all talking about using the amendment process, but do you notice the common theme here? In every case, they're saying if there's an error or a flaw in the Constitution that is causing problems, then of course we correct and amend the Constitution. Now, what did they say we are supposed to do in cases where the federal government is overstepping constitutional bounds? It's not a constitutional flaw, it's that they're simply not following it. There are many places we can point to where the Founding Fathers talked about what to do in those cases. One, for example, is Federalist 46. Madison says in Federalist 46, the means of opposition to it, to overstepping constitutional bounds, are powerful and at hand. He lists many. I'll show just a few. The first one, he says, is the disquietude of the people is a great tool. I love that word, disquietude. I'm going to try to use it more in my own vocabulary. What does disquietude mean? That really means the people are getting upset. The people are unhappy with your performance in office. And if, as an elected official, too many of your constituents are upset with the way you're working in office, the way you're upholding your oath, you're not likely to be reelected. He referred to this as a powerful tool the people have, but it's not the only tool by any means. On the state level, in particular, he talks about the refusal to cooperate with the officers of the union, that they won't help in the implementation of unconstitutional actions of the federal government. He also said state legislators have the power to create legislative devices to present obstructions, which the federal government would hardly be willing to encounter. They can help block unconstitutional actions, as well as not complying and not helping with them. These are all powerful tools. Notice what's absent from this list and all others. When the Founding Fathers talk about solutions to cases of overstepping constitutional bounds, they never talk about Article 5 as a solution there. In fact, historically, take for example, in 1798, when Congress passed the Alien and Sedition Acts, these were, among other things, making it illegal to speak against what the President and Congress are doing. Clear violation of the First Amendment. James Madison and Thomas Jefferson were very concerned and upset about this unconstitutional law that had just passed through Congress. Did they turn to Article 5 as the remedy? No, they did not. What did they do? They wrote the Kentucky and Virginia resolutions of 1798, which were talking about nullification. The states have the power to stand up and say, no, we will not help in implementing this law. We will refuse to cooperate with the officers of the Union, creating legislative devices to present obstructions to it as well. So both in their words as well in their actions, we see that in cases of overstepping constitutional bounds, they did not turn to Article 5. This is a myth that has been created today by those that are presenting this Article 5 convention as the solution. Now, recently in 1989, the Nevada State Legislative Assembly had an application for applying for an Article 5 convention, which they were submitting a rescission of. So this is the U.S. congressional record saying, we want to take back our application for this convention. Why? Effectively, they said we were tricked into applying for it. Here's their exact wording. This application was induced by fraud. That's a powerful word. They called it fraud. The people that were presenting to us this plan of you've got to apply for an Article 5 convention misled us. And they list some of the things they felt they were misled on, some of the points, some of the claims they made. I want to examine some of these claims that are being made today that are very misleading. So one of the claims that I talked about was we don't need to worry about the precedent set by 1787. This is one of the most everlasting debates between those that are promoting a convention and those that are opposing it. What really happened in 1787? Here's one of their claims. The Constitutional Convention of 1787 was not called under the Articles of Confederation. The Articles made no provisions for such a convention. In his conclusion, he draws from that is, therefore, it could do anything which the states allowed it to do up to and including choosing a method of ratification for its own proposals. So here's the claim. The 1787 convention could do anything they wanted to. They were free to do whatever they felt was necessary as long as the states said so. This comes from Robert Kelly, staff counsel for Convention of States. The co-founder of Convention of States, Mark Meckler, in a recent debate, December of 2016, he makes the claim, the greatest authority on the subject is Madison, who was at the 1787 convention himself and wrote in Federalist 40, if we want to know what the authority of the framers actually was, look to their commissions. You allege the 1787 convention ran away, and I would ask you the question, and it's a critical question, have you read those commissions? This is one of those times I'm watching this debate, and I wished I could jump through my computer screen and sit next to one of his opponents and answer this question for him. What he's suggesting is, and he's exactly right, Madison said, look to their commissions to see what their authority was. And he's then implying the 1787 convention didn't run away, they followed their commissions. I have read those commissions. I'm a little analytical. I put together a whole spreadsheet and itemized everything that every one of those commissions say. What are the commissions? These are the instructions from the states to their delegates that attended the 1787 convention, telling them, here's what we want you to do in order to represent us. That was the authority they were given from their states. And as I read through those commissions, that is why I conclude the 1787 convention exceeded their commissions. They overstepped the bounds the states gave them. I'll demonstrate. So first of all, they're talking about the convention not being under the authority of Articles of Confederation. That was our first constitution, the Articles of Confederation. This was the existing constitution, the supreme law of the land, when the 1787 convention happened. They said in this Articles of Confederation, Article 13, any changes to be made to our Constitution must be agreed to in Congress and afterwards confirmed by the legislatures of every state. Keep those two in mind. We're going to see them again and again. Agreed to in Congress, confirmed by the legislatures of every state. So, when the 1787 convention happened, it was first triggered by or called by a convention the previous year. In Annapolis in 1786, 5 states got together to discuss trade problems they were having between the states. And as they tried to resolve the problems, they concluded that the Articles of Confederation is the problem we're facing. We need to call for a convention that proposes changes to the Articles of Confederation. So they submitted what was called the Annapolis Convention Call for the Convention of 1787, where our U.S. Constitution was written. And they concluded by saying whatever they come up with in this convention should be proposed to Congress, and when agreed to by them, and afterwards confirmed by the legislatures of every state, then it becomes part of this Constitution. Does that sound familiar at all? Agreed to by Congress, confirmed by the legislatures, that's what we just showed on the previous slide. That's a direct reference to Article 13 of the Articles of Confederation. That was the existing constitutional requirement, and Annapolis was recognizing that. You're going to have to follow the ratification process as dictated by the existing Constitution. Next, as we start looking to the state commissions, just like was told to us by Mark Meckler on the previous slides, look to their commissions. Let's start looking at those. The first state to issue a commission to their delegates was Virginia. And they said, whatever you come up with in that convention in 1787 will be reported to Congress, and when agreed to by them and confirmed by the several states, will become part of the Constitution. That sounds familiar, doesn't it? Again, referring to, you're going to use the Article 13 ratification process. The next state was Pennsylvania, and they used almost the exact same words. Refer to Article 13 for the ratification process. Every state thereafter, we have Delaware, Georgia, Congress, New York, Massachusetts, South Carolina, Maryland, and New Hampshire, all using very similar wording, referencing that whatever you come up with in this convention must be agreed to by Congress and afterwards confirmed by the legislatures of the states. That in total is 9 states out of the 12 that attended the convention, plus Congress, who gave their stamp of approval on this convention, and the Annapolis Convention that first started. All are referencing what? You're going to have to follow the existing constitutional requirement of ratification. Congress approves it, and all state legislatures approve it. Now, you might remember in history, the 1787 convention, Rhode Island didn't even show up. They were protesting this. But they sent a letter to the convention explaining, here's why we didn't come to the convention, some of our reasoning, but whatever you come up with, even though we're not there, remember, any alterations must be agreed to in Congress and afterwards confirmed by the legislature of every state. So now you have 10 states on record saying you've got to follow the existing constitutional ratification process, and Congress, and the Annapolis Convention, and of course this is the constitutional requirement. Is this a limited convention? This convention was clearly being told you've got to follow this ratification process. Did they do that? No. In fact, at this point we turn to Federalist 40 again, James Madison, who tells us very clearly, it is admitted that the convention have departed from the tenor of their commission. Remember the first quote from Madison? Look to their commissions? We've looked to their commissions, haven't we? They did depart from their commissions, and now Madison's telling us the same thing. They've departed from the tenor of their commissions. Instead of reporting a plan requiring a confirmation of the legislatures of all the states, they've reported a plan which is to be confirmed by the people, not the state legislatures, and to be carried into effect by 9 states only, not 13. They changed who ratifies, and they changed how many would be required for ratification. They greatly lowered the bar. Why? Well, they recognized that this new Constitution was a significant shift of power away from state legislatures. How many state legislators do you know that would willingly surrender a large portion of their power? Not likely, is it? They knew that at this time as well, that this new Constitution would have no chance of ratification by the existing requirement. So they felt it was necessary to violate their commissions and to change the ratification process to an easier, more likely process. Now, as you read through Federalist 40, there's one thing you'll see as a very common theme. I recommend highlight every time that Madison mentions the people in Federalist 40. The majority of them are talking about his plan for appealing to the power of the people themselves. And this is where Madison himself is refuting the claim that what they did was illegal. I'm often given that charge as well. Oh, you must just believe the Constitution was illegally adopted. No, I don't. I side with Madison on this. Madison clearly tells us that the authority that they acted under was not the authority of the states or Congress or the existing Constitution. He says that they appealed to the right of the people to abolish or alter their government, as to them may seem most effective in protecting their safety and happiness. They appealed to the highest authority in the land. Remember, we the people created the states. And through the states, we created the federal government. We the people are the highest authority in the land. And so he went over the heads, as a convention, they went over the heads of the states, Congress, and the Constitution and appealed to the highest power of the people themselves. This is clearly a false claim. The 1787 convention was, according to the commissions from 9 states, plus Rhode Island and everyone else, under the Articles of Confederation. And yet, they ignored that. The precedent this sets is one that the convention promoters cannot escape. That is, that even if a vast majority of states gives instructions to their delegates, like was done in 1787, they can ignore those limits and appeal to the power of the people themselves to alter or abolish our current Constitution. Now, oftentimes when I'm in debates with people on this topic, they can't go anywhere on that history. It's clear, it's solid. So they'll divert to another argument. Oh, well, they can't possibly change the ratification process today, even though they did in 1787. And one of the arguments I have, this one comes from Professor Robert Nadelson, where he tells us the Supreme Court has already ruled that conventions can't change the ratification process. In Hawk versus Smith, 1920, the Supreme Court ruled that no legislature or convention has the authority to change the ratification process. When a law professor cites Supreme Court rulings, do you go home and look them up to see if he's telling you the truth? I would recommend you start doing so. That's what I did. I went home and looked up Hawk versus Smith, and this is the closest language in the entire ruling to what Nadelson said. The language of the article is plain and admits no doubt of its interpretation. It is not the function of conventions or, wait, that doesn't say conventions. What's wrong here? It's not the function of courts or legislative bodies, national or state, to alter the ratification method which the Constitution has fixed. It didn't say conventions, did it? Where did this claim come from? It's a little baffling. Clearly what he's saying, Hawk versus Smith says, it does not say. And whether this is just an inadvertent error or an intentional deception, either way it is false. What do we learn from this? Well, number one, the Supreme Court has not ruled anything about conventions having or not having the power to change the ratification process. If they were, that would actually strike at the foundation of the Constitution itself, wouldn't it? For that is how our Constitution came into being, was a convention changing the ratification process. They have some serious problems with the claims that they're marketing to our state legislators. This one is clearly a distortion of what the Supreme Court has said. Now, what could happen? Here we have a law professor, Sanford Levinson, who wrote a book, Our Undemocratic Constitution, where he thinks we need to change our Constitution to be much more of a democracy, which those who understand the difference between democracy and republic know how dangerous of an idea that is. He says we should have an Article 5 convention to consider the adequacy of the Constitution and his hope, if thought necessary, draft a new Constitution. And he proposes will be submitted to the electorate for its approval or disapproval by majority vote. What's he suggesting? That at the end of an Article 5 convention, we should change the ratification process and put it out to a simple majority vote of the people themselves to ratify or not these new constitutional changes. That causes some concern to me. I've seen the simple majority vote across our nation vote for a number of things that I think are hostile to our Constitution, our principles of liberty. Conservatives in particular are concerned about if we were to lose the Electoral College and go to a simple majority vote for our president, what that would entail. So there are definitely some concerns here. Now, James Madison had some concerns about calling for an Article 5 convention as well. He wrote a letter to George Turberville in which he tells us, having witnessed the difficulties and dangers experienced by the first convention, the 1787 convention, which assembled under every propitious circumstance, I should tremble for the result of a second convention, meeting in the present temper and under all the disadvantages I have mentioned. In this letter, he is warning against an Article 5 convention. Those that are promoting a convention in order to do some damage control on this have made some very interesting claims. They'll say, oh, he wasn't talking about an Article 5 convention. This letter was written before the Constitution had even been ratified, so he couldn't possibly be talking about Article 5, which was written into the Constitution. Is that true? Simple timeline reveals. Remember, it was only 9 states that they said had to ratify this new Constitution. That happened in June 21st of 1788. In September 13th of 1788, Congress declared our new Constitution to be ratified. James Madison wrote this letter to George Turberville November 2nd, 1788. And so chronologically, clearly, Madison already knew we had ratified the Constitution. Article 5 was now an option, and he was warning against the use of it. And just to make things more clear, he even refers to the convention he's warning about would be triggered by the previous application of 2/3 of the state legislatures. Remember I said Article 5 requires 2/3 of the state legislatures applying for the convention, 34 states by today's numbers. If he's not talking about an Article 5 convention, can you think of any other kind of convention that's triggered by the application of 2/3 of the state legislatures? What else could he be talking about there? And the answer is there is none. This is clearly a warning against the dangers of an Article 5 convention, and his main concern is the present temper of America. At the end of 1798, in the end of 1788, he was concerned there was a lot of political discord going on. Are we any better today? Do we have a lot more unity politically among the people? Is this a good time, or should we be equally concerned about the present temper of America? And as I'll show later, there's a lot of concerns about the present temper and the present knowledge of America regarding constitutional history. This is clearly another false claim. Now, oftentimes we point to solutions like Madison did in Federalist 46, nullification, that the states can stand up and refuse to help implement unconstitutional laws. Because of their number 2 claim that I illustrated, this is the only solution, Article 5 is the only solution we can use, they have to always discredit any other valid solutions. And so nullification, they'll point to, that violates the Supremacy Clause. What does the Supremacy Clause say? Article 6, Clause 2, it says, this Constitution, and the laws of the United States which shall be made in pursuance thereof shall be the supreme law of the land. What does in pursuance mean? In following. Laws that are made in following the Constitution are supreme. What does that imply about laws that are not in following the Constitution? Let me bring in an expert on that one. Here we have Alexander Hamilton in Federalist 33 telling us, acts of the federal government which are not pursuant to its constitutional powers are merely acts of usurpation That is theft of power and will deserve to be treated as such. How do you treat an act of Congress that is unconstitutional? How do you treat that as an act of usurpation? By not recognizing it having authority. Here and many other places throughout the Federalist Papers, Madison and Hamilton both suggest the idea of states refusing to help implement unconstitutional laws and even blocking them when necessary. So clearly, a proper understanding of the Supremacy Clause declares that only laws in following the Constitution are supreme. Nullification is only properly used when it's being used against unconstitutional law. And that is what our elected officials are swearing an oath of office to do. They're swearing an oath of office to uphold the Constitution. This is clearly a false claim. Article 6, Clause 3, requiring every elected official, state, local, federal, to swear an oath to uphold the Constitution, that matters most, upholding the Constitution, when the federal government is not. That's when it really means something. That is nullification. Therefore, I call the nullification is the Article 6 solution. There truly are other solutions the founders pointed to. On this topic, we have an article here talking about state governors admit the federal government needs state help with most federally funded programs. When we were looking at a government shutdown, the National Governors Association sent a panicked letter to Congress saying, we don't know which of these federal programs are being shut down and which ones aren't, and what we're supposed to be doing. Since you rely on us, and here's the key part, the federal government depends on states to get these things done, to implement their unconstitutional acts. We need your guidance on which ones you're shutting down. By doing so, they just admitted where the shutoff valve is, didn't they? The states have it in their hands to shut down a majority of the federal programs which are unconstitutional. And pressure from we the people to our state governors and our state legislators is what's needed for our states to stand up. Now, is this happening today? Absolutely. In fact, here's a recent article from the 10th Amendment Center which tracks these types of things. And so far in the year 2017, they declared we've seen already over 200 bills that would qualify as nullification bills being introduced in state legislatures all over the country. This is a growing movement. It has a long and successful history throughout our nation's history of states refusing to implement unconstitutional bad laws. This brings up what I would refer to as the ruby slipper concept. You all are familiar with Dorothy Gale, the Wizard of Oz, where throughout that story, she is following the yellow brick road trying to find the wizard because she believes he is her only solution to her problem of getting back to Kansas. What does she find? The wizard turns out to be a fraud. And she had the power all along. In the same way as the Nevada State Legislative Assembly discovered that their application for an Article 5 convention was a fraud, just like the wizard. And they already have the power all along. Our state legislators have already have the power to rein in the federal government, as do we the people. We don't need to change the Constitution. We have the power now. So going back to their three claims that I started off with, they claim that this was the purpose of the Article 5 Convention to rein in an out-of-control federal government. Clearly not true. The Article 5 Convention was for correcting errors in the Constitution, not for reining in an out-of-control government that simply won't obey the Constitution. They claim that this is the only solution. Again, that's false. The framers recommended many solutions to usurpation, but they did not include Article 5 as one of them. And finally, they claim it will be totally controlled by the states and 1787 wasn't a runaway convention. Well, according to Madison, the 1787 convention exceeded the tenor of their commissions. There's no escaping that. A convention today can do the same. It's time for us to look to the founders' true solutions, not fall for these false claims of this Article 5 convention being the solution to our nation's problems. We already have the power. We don't need to change the Constitution. And as we'll demonstrate in Part 2, there's tremendous risks with the various amendment proposals that are being circulated now.